Good afternoon. Thank you, Wolfgang and Claire and ECCHR for inviting me and hosting this very important tribute to Michael Ratner's legacy. And I'm going to talk about what I personally regard as the kind of crown jewel of his remarkable legacy. And Michael will have to forgive me the imperial metaphor, but it's his decision to challenge Guantanamo at a time and a place when virtually nobody else dared to. So this is an account of Michael's courage and his commitment to principle. So according to Michael, he opened up the New York Times one November morning and read about a startling order titled Military Order Number 1, issued by George W. Bush, that authorized the Secretary of Defense to indefinitely detain individuals captured in the so-called War on Terror, and to try some individuals in as yet unconstituted ad hoc military commissions. And Michael saw that for what it was, a kind of shocking arrogation of power by the United States. And when combined with an understanding that these detention operations would be located in Guantanamo, he recognized that he had to take action. And this is sort of an important point here about Michael's long-term political experience and perspective, because this was not his first time dealing with Guantanamo. In 1991, after the humanitarian crisis in Haiti, hundreds of Haitian refugees were intercepted, interdicted by the U.S. Coast Guard on the high seas and detained in Guantanamo, including a great number of HIV-positive refugees. And Michael, along with a number of others, sought to represent them and guarantee them basic refugee protections and permit their admission into the United States. And at that time, the then Bush one administration, Clinton administration, argued that these individuals were not entitled to any human rights because they were foreign nationals held on foreign soil. So Michael saw what was coming in Guantanamo, and sure enough, the Bush administration chose Guantanamo specifically and intentionally as a location that would be outside the jurisdiction of the U.S. courts, so they could deny detainees access to law, access to courts, and also access to lawyers. And the Bush administration denominated all of the detainees in Guantanamo who were apprehended, as we later learned, all over the world, not just by any means on the battlefield, denominated them enemy combatants, which is a term that has really dubious validity in international law, and thereby denied them any entitlement to any human rights whatsoever, any legal recognition whatsoever. And what sort of made the Bush administration project particularly dangerous, I think, is that they arrogated for themselves all of the power provided by international law, in this case a theoretical power to hold individuals captured on the battlefield and to prevent their return to the battlefield, at the same time rejecting any of the kind of necessary corresponding limitations on that power. That is the obligation at a minimum for humane treatment and adjudication by a competent tribunal. So this was a really startling arrogation of power, and as we sort of, Michael surely suspected, although and later confirmed, the location of Guantanamo was not really ever about adjudicating guilt or innocence or punishment. It was a denial of the application of law so that the administration could conduct endless, long-term, brutal interrogations to collect intelligence. So it's in that context, and then of course the administration, engaged in that brutality, denied legal protections, a form of legal erasure, and then invoked all of the imagery and iconography of terror. These are the worst and the worst, the masterminds behind 9/11, and one particularly colorful phrase, the general said, these are the kind of people who could gnaw through the wire of a C-17 plane to bring it down. sort of interjecting massive fear in the population and demonstrating in a kind of like a security theater that this was necessary to protect them. So it's in this background. And with the World Trade Center practically still smoldering, that Michael, joined by a couple of also courageous death penalty lawyers, chose to file cases, habeas corpus petitions, on behalf of a number of Australian and British detainees in January in 2002. As he said later that he had no expectation of winning in those early cases, he filed 100% on principle. And we've talked a little bit here about sort of CCR's philosophy of movement building. And sometimes we talk about it, we sometimes try to challenge power and build powers, challenge state power at the same, and build the power of movements, and the work works most successfully when they're joined. But there was no movement at this point. It was a pure principled challenge to a shocking executive decision, and a denial of the most fundamental principles of law. Though I want to come back to a way in which ultimately this work was connected to movements. But again, as I say, he filed sort of 100% on principle. The David Hicks and Shafiq Rasool, and Mr. Abbasi had no idea they had attorneys. Shafiq Rasool's case was being argued in the Supreme Court in 2004 on behalf of a legal team, and Shafiq Rasool had no idea he had attorneys. The petitions were filed in this ancient, common law device as on behalf of their families. And so he had no expectation of victory, but the point was to open political space and a political conversation to change people's minds around the legitimacy of this practice. And remarkably, 2 years later, his kind of principled vision was adopted by the Supreme Court in a case called Rasool versus Bush in 2004, which held that invoked Michael's sort of rhetoric about the importance of the habeas corpus as a check on executive power, the importance of the rule of law, and held that detainees could challenge their detentions, that they could have lawyers and have some access to the courts. And there was a long kind of subsequent fight about the scope of that access to the courts, for sure. But it's just interesting to note that between 2002, when Michael and CCR literally could get no other NGOs to work on these cases and could not basically find what we call local counsel, just a lawyer in a different jurisdiction to do the ministerial act of filing the papers for you. From that point in 2002 to 2008, as a result of his vision about opening up the political and legal space, we went from that moment in 2002 to, by 2008, a legal and a political consensus that Guantanamo was illegal and had to be closed. And so that is an effectuation of his principle. So let me just turn quickly to the couple of movement pieces, one that happened after the Rasool decision and one that happened before that I think can be instructive. After the Rasool decision, Michael and CCR recruited, trained, and coordinated literally hundreds and hundreds of lawyers from all aspects of the American bar, the academy, the private bar, public interest organizations from all over the country to represent all 790 detainees. His vision was, and this is what Joe Margulies says too, if we get lawyers down there, if we open it up, we can shut it down. We can start telling stories about what's happening there, which ultimately, in fact, was birthed by the legal interventions. We can close Guantanamo. And that, in its sense, was a movement effort, a movement of, a bit of an elite movement but of the legal bar. We've sort of called it the Guantanamo Bar Association, one commentator called it the greatest mass defense effort in United States history that he helped bring about. And then one other kind of, seems like a bit tangential, but might hold some promise in thinking about sort of long-term strategies around challenging human rights abuses during wartime, is a bit of a story about someone named Fred Korematsu. Fred Korematsu was a Japanese-American citizen who was detained under Roosevelt's internment order to intern all Japanese Americans, predominantly on the West Coast, without due process of law. And in 1944, despite what looks to us as an obvious sort of like racially motivated and arbitrary detention process, the Supreme Court upholds the president's authority to detain Japanese Americans. And it was, I think, for 30 years, a little thought about or understood decision, except for some really remarkable activism by the Japanese American population that sort of unearthed evidence of wrongdoing by the executive branch and sort of fabricated justifications for the internment and basically mobilized in such a way that ultimately gained an apology from the legislative and executive branches for internment, and then through that activism made the Supreme Court decision in 1944 illegitimate, even though it wasn't overturned. And I think and Fred Korematsu wrote a very important brief in the Rasul case in 2004, reminding the court about its mistakes before, which he could only have done because there was a political consensus that the court had erred before and should not do it again. And so I'll just put a placeholder there for thinking about how that kind of strategic activism and can hold, is worth it and can bear fruit in the future when we're thinking about these issues.
Yeah, good afternoon, and also thanks for this wonderful event today. Speaking about Guantanamo Bay, my first case in which I was involved, but not as a lawyer, but as a judge, goes back to 2001. At that time, I was one of 8 international judges at the Human Rights Chamber for Bosnia and Herzegovina in Sarajevo, which was set up by the Dayton Peace Agreement. It's one of these human rights annex. So we were the highest court in Bosnia, a human rights court, and we could give orders that were also implemented because Bosnia was at that time under a kind of international protectorate. And in October 2001, so 1 month after 9/11, the US government told the Bosnian government that they had to detain 6 persons, Bosnian citizens of Algerian origin, because they had evidence that they were planning an attack, a bomb attack, on the American embassy in Sarajevo. That was the reason. The Bosnians, of course, complied. They arrested them. And then they asked the Americans, but can you give us some kind of evidence? Because we haven't found anything, so where does that come from? And then the ambassador said, no, we can't. That's CIA information. It's top secret. We cannot tell you. And then the Bosnian judges said, but you have told us under the Dayton Peace Agreement that we have to comply with the rule of law. So there is something like a maximum period of police detention, and then it has to go before a court, and the court has to decide on the basis of the evidence. So if you don't give us evidence, we are afraid that the courts would actually release them. And at that time, they already had appealed to us, and finally, because the US didn't provide any kind of evidence, the only thing that they provided was that in the kind of telephone directories of one of the 6, there was a telephone number of one person who was fairly close to Al-Qaeda. That was everything that they had. So finally, they were released, and we also, at that time, made an injunction preliminary order to tell the Bosnian authorities until we have decided the case on the merits, you cannot, also you are obliged not to send them or extradite them or rendict them, whatever, to the US. So then the question was, they were actually released from the court in Sarajevo, and on the other side of the street were American soldiers, part of the international peace operation called ECCHR at that time. And they just switched and said, now we are acting as American soldiers, and we were arresting them. And then there was a kind of a negotiation between the High Representative, at that time was Wolfgang Pettrich, the highest civilian authority in the country under the Dayton Peace Agreement, and of course the different ambassadors of France and Germany and other countries, and saying, I mean, since this is a binding interim order, you should comply with that, and we have to wait until the chamber hands down its judgment. And I was told then by the French ambassador what the American ambassador finally said, fuck the chamber. And that was it. They were taken to Incirlik, and then in January 2002 they were in Guantanamo Bay. So among the first detainees there. And of course I came across them afterwards again as UN Special Rapporteur on Torture. As you said, I was appointed in 2004. That was the year of Rasul versus Bush. It was the high time. It was after Abu Ghraib. So there was a different kind of awareness. So much of my time, those 6 years, I really spent on the so-called war on terror. So we started already in 2004 an official investigation into the situation, the human rights situation in Guantanamo Bay, where the Bush administration at the beginning didn't want to cooperate at all. Then they gave us some not yet declassified documents, but not very, very useful. And then the question was that we would actually visit Guantanamo Bay, because in every of these United Nations special procedures investigation, you should go to the spot and interview the detainees, etc. So we said we would like to do that. At the beginning they said no way, and then there was a lot of pressure. So finally we entered into one of the most bizarre type of negotiations that I've ever had, partly in Washington, partly at the UN in New York. So we are quite high-level people from the National Security Council, the Pentagon, the State Department were actually coming, and we negotiated the terms of our visit to Guantanamo Bay. So they said, in principle, we are inviting you. And it would have been in December 2005 that we would visit. And then they said they have certain conditions. I said, what? Yeah, you have 5 special rapporteurs, that's too much, so 3 of you can come. I said, all right, we discussed with Paul Hunt and Leandro Despeur whether they would be willing not to come, so finally they said yes. Then I said, it's only a short period of time. We also said, all right. But then the question was, what's about private interviews with the Guantanamo detainees? And then I still remember that I think it was Michael Waxman who then said, but I mean, if you go to Guantanamo Bay, it's very unlikely that you actually come across detainees. I said, very, very strange. I mean, there are, at that time, about 600 people there. I said, yeah, there might be on recreation when you are coming. So at the end we said, okay, either it's very clear you have to give us assurances that we can speak in private with them, otherwise we would not come. And that was a long negotiation, and I still remember Condoleezza Rice finally complied. She said, it's fine, it's coming. It was only Donald Rumsfeld who said, no way that you can speak to detainees, and then we said, no way that we are coming, because it doesn't simply make sense. But we did our report. It was 5 special procedures, special rapporteurs. We presented it to the newly established Human Rights Council in February 2006. And I think we were the first international investigation body that clearly said Guantanamo Bay itself is illegal. It's violating the right to personal liberty under Article 9 of the UN Covenant on Civil and Political Rights, which the United States had ratified. We have found quite a number of evidence of torture. That's very well documented. So it's a violation of Article 7, and the UN is also party to the Convention against the US, to the Convention against Torture. And we clearly came up with a recommendation. It needs to be closed down immediately. That was later followed by many others, that this kind of demand. And of course, the Bush administration said when the report was published, simply everything is wrong in there. The legal analysis is wrong because the international human rights law doesn't apply anyway, etc. So simply putting everything into question. But finally, at least when Obama came to power, he at least, as one of his first actions, was to promise closing down Guantanamo Bay. Bush actually at that time came to Vienna, and we met at the European-American Summit in June 2006. And he kind of said, so publicly, he said, we are ready to close down Guantanamo if you Europeans take the detainees. And I spent quite a lot of time trying to convince European politicians to take Guantanamo detainees, and I should also say this was really shameful for Europe. It was just a few people, like Germany, I think, took 2, and Switzerland and Portugal, but most of the European states were not willing to take anybody. So in that sense, I became then kind of an ally of the Bush administration to try to assist them of getting Guantanamo detainees away.
Thank you. I was just wondering, before we open the floor, perhaps you want to Barry, you want to maybe add or react to that specific story. Perhaps also, I mean, if you like, it would be perhaps interesting if you could also give your view on, so to say, CCR going transnational in terms of fora. I mean, so the Rumsfeld case is this one example where the CCR, beyond the efforts within the US system, which you explained regarding Guantanamo, went sort of transnational, like in many other cases, and perhaps also the rendition saga, but yeah.
Sure. So one reaction that I have to Manfred's account of his really genuinely heroic work during this period in incredibly difficult circumstances is that it's, you know, I told a story about a litigation battle that, and you know, in theory ended in 2008 with a recognition that detainees should have full rights to challenge their detention. But in reality, you can count on one hand, maybe 1.5 hands, the number of court orders there have been releasing detainees. The Guantanamo closure came as a result of concerted international pressure, intentional pressure through the Special Rapporteur's Office, international NGOs, European parliaments, English parliamentarians, and this kind of extra legal effort of lawyers to visit the base and discredit the legitimacy of the base, and expose the myths of, and tell stories of innocence and incompetence and torture. I think that's an important thing to recognize as well. But again, sort of trace back to the decision in part in Rasul to open up the camps and allow sort of international pressure and domestic activism to transform and ultimately, result in the release of what at this point has been 720 something detainees. So that's an initial reaction. And so on the one side, there's been attempts to close Guantanamo, and then there's been a kind of civil society legal attempt to hold Bush administration officials responsible for torture, rendition, arbitrary detention, responsible in the sense that they should be, a court should judge their conduct illegal and award compensation to victims. What became apparent very early, and even contemporaneously with the Rumsfeld cases, is that U.S. courts were not going to hear any of those cases. Sort of one doctrine over another, one sort of principle of immunity, or another shielded U.S. officials from accountability inside U.S. courts around rendition, around the CIA program, around torture in Guantanamo, torture abroad. And so that led to some recognition based on, a number of the Central American cases around Argentina that we should be thinking about transnational fora, both as an accountability mechanism on its own, also as a fora to develop a record of the human rights abuses by the Bush administration, and Katie Gallagher is here and has led CCR's effort to develop that record, which is a deep and thorough and permanent record lodged in these tribunals. And as Michael said, to and kind of ensure that Europe is not a place where these officials can ever travel, which is some symbolic harm and some dignitary harm to them. But also, hopefully in theory, if these cases start to develop in these transnational forms, that would put additional pressure on U.S. fora to start recognizing the legitimacy of these claims for accountability.
Perhaps it's also quite interesting when we asked the ex-Guantanamo detainees, because we carried out many interviews with those who had been released in London, Paris, and Madrid, etc. And many people said the worst pain that they had was during the rendition flights, being for quite a long period of time, if you did it from Afghanistan to Guantanamo Bay, or that to be all the time in these jumpsuits, hooded, shackled, handcuffed, you couldn't move, you were just on the floor. They said it is creating a lot of pain in your back, and then of course the way they were treated. The other one was those who were on hunger strike, and where they said the way how they were force-fed was extremely brutal. And of course also the cold and hot. So this, how did Rumsfeld call it, some kind of...
Sensory deprivation.
Yeah, that was not really sensory deprivation. He had a special name for that. But that meant for them really being on the one hand in the heat of Cuba, and then for 3 days and nights in a fully air-conditioned metal or concrete box, without anything, naked. You couldn't cover yourself, and shivering, and of course the sensory deprivation, to be for 2 or 3 weeks, every 15 minutes being woken up and being totally disoriented. And we, perhaps later then, we did another study, a joint study on secret detention in the fight against terrorism, which we presented in 2010. And that was not only US related. In general, we identified 66 states around the world that are using, where we had really evidence that they were using secret detention in the fight against terrorism. And of course, many of them were allies of the US, so it was part of the CIA program, whether it's Afghanistan or Pakistan, Thailand, Poland, Lithuania, and Romania, 3 European countries, and many other countries. And again, looking into the testimonies of many of those people in the way how they were treated. For me, from all those black sides of the CIA, probably the worst was the prison of darkness in Kabul, where people said, you are simply getting mad. It was totally dark in the basement, and 24 hours, very, very loud music or just noise. You were handcuffed and shackled, most of them. And many of them said, you either survive, but many people actually got mad. So that was for me also very interesting. And there, that was under the Obama administration already, but there was very, very little reaction then also by the Human Rights Council of the United Nations to really follow up.